I'm not alone in studio tonight. I'm joined by Advocate Steve Ogolla, and not for the first time. Steve, happy to have you back. What do you make of those protests in Karatina over the arrest of the Madeira Member of Parliament, Rigathi Gachagua?
Well, there are two dynamics, Olive. Politicization of corruption or criminalization of corruption. I think because we are heading towards an election and the political elite, they are right to play politics with the arrest of Rigathi Gachagua and his intended prosecution. But from a practitioner point of view, if you look at Article 157, sub-Article 11 of the Constitution of Kenya, the Constitution anticipates that when the arrest is made, investigations have been completed and that there is evidence that can support the charges that are proposed for him to face. The DPP, in making the decision to charge, is required to consider two critical elements: evidentiary test and the public interest test. So we can only pray and hope that in terms of assessing the evidentiary test, that there's evidence, prima facie evidence, that if left unchallenged could lead to a conviction. In terms of public interest test, that is in the public interest that corruption be prosecuted. So until he's charged and he takes plea and evidence against him is disclosed, it would be premature, a bit early for a practicing advocate like myself to jump into the fray and take sides. I think we'd wait for disclosure of material evidence that the prosecution intends to rely on at the trial. Only then can we then see if that decision to charge has been made in error or if it has been made in compliance with Article 157, sub-Article 11 of the Constitution.
All right, then, as an advocate, you've said, let us wait and see what evidence is proffered in court.
Yes.
What then do you say to those politicians who have taken it upon themselves on podiums, week in, week out, to say that they're being persecuted?
That is political conversation, and Kenyans must permit that to happen. Political conversation, actually 12 months to election, is normal. Propaganda is normal. Maybe there may be genuine, legitimate concerns that those who don't support the president are targeted in the war against graft. That is the kind of conversation that you cannot mute. So Kenyans will continue to be entertained with such kind of conversation. We will never know for sure whether there's merit in political conversation or not until someone is arraigned in court and evidence adduced. So, if there's a conviction, then it doesn't matter that people thought the war on corruption was targeted against Deputy President William Ruto's allies. But if there was no evidence to sustain a conviction, then maybe those who claim or suggest that the war on graft is targeted to DP's corner, then they may have some political dividend. But at this stage, it's conversations, it's allowed by the Constitution, freedom of viewpoint, freedom of expression. Let them pontificate, let them express themselves.
Okay, I also wanted to comment on the investigations into two High Court judges, but just before we get into that, my concern is this. If we allow such continued political rhetoric accusing the DPP and the DCI of political targeting, one, doesn't it erode confidence in those institutions? And two, do we not then see situations like we've seen in Karatina?
Certainly, if you keep on antagonizing key constitutional and statutory institutions such as the DCI and the DPP, then it erodes public confidence, because public confidence rides in the first instance on perception. Then, in the second instance, on how those officers animate the independence of their offices. If there's a perception that this DCI and DPP are being used to fight political battles, then does it even matter that they're not being used? Because they say in terms of governance, perception is everything. And once it has been established, then your version of the truth doesn't really matter. But if there is also, so away from perception, so perception can actually alter how people view the independence of those offices. Is that a problem? Yes. Is it a problem for those offices? No. It's a problem for the public. Let Kenyans decide. If you want to strengthen our investigative agencies and you want to strengthen the DPP, the first thing that you must give them the benefit of doubt that they act in good faith.
Okay.
Until you begin to show otherwise. If they begin to show otherwise, and how can you show otherwise? Maybe the rate of conviction in court is actually questionable, wanting, then you can now raise legitimate questions. But I just want to urge Kenyans that sometimes political noise can have unintended political benefits of slowing down potential undisclosed abuse of office, if it existed but had not been detected.
Steve, I always wonder about these injunctions against investigations. can you stop the investigative authorities from conducting what is primarily their job?
The short answer is no. You cannot stop DCI from conducting investigations unless you raise the manner in which you raise questions around the manner in which those investigations are being conducted. For instance, if you're conducting a search without a search warrant, then there's a legitimate concern and legitimate interest for the judiciary to intervene and interfere with the power to conduct that search until it has been regularized. So I think when the court intervenes and interferes with the investigative role, they must be careful to calibrate what exactly are they saying. They cannot say that do not investigate, because that would be curtailing unfairly the mandate of the DCI. But they can say, if you want to conduct investigation, can you adhere to established procedures? If you want to arrest over the same allegations and there's genuine concern that there may be a risk that the power to arrest is being abused or the power to charge is being abused, then the court can say, no, I'm not saying that you cannot arrest or you cannot arraign in court or you cannot charge, but I'm saying that pending the resolution of the questions relating the procedural and substantive concerns around the power to charge, the power to investigate and arrest, then do not interfere, do not take any action until I review your conduct. So this is the Judicial Review Division of the High Court, which has basically been invited to audit. Actually, that is the proper term. The court has been invited not to stop the functions of the DCI, but to audit what they have done, just to be sure that there's compliance with procedural requirements.
Okay.
Yes.
And then is the DCI stepping on the toes of the JSC? Because where is the line?
I think what is raising concern is that this matter has been clarified in DCJ Mwilu's case, that if you want to investigate, arrest, and arraign a serving judge, then there's a two-step process to that. The first step is, if there is genuine concern to believe that a judge has committed an offense that can lead to removal, because all these offenses that judges commit actually also can trigger removal proceedings, then can you defer this to the Judicial Service Commission, who is the employer, to investigate and inquire into this conduct of the judge or the allegations that are being leveled against the judge, and if they are found to be merited, then the judge will stand removed. Once he has been removed, then you can prosecute him. There's good reason for sticking to that process for two reasons. One, if you look at the constitutional arrangement of power between the three arms of government, there is what is required as courtesy and comity between offices. Courtesy and comity between offices is that when you look at the judiciary as an independent co-equal arm of government, if you disrupt the functions of the judiciary by just plucking a judge from chambers and taking him to court directly, even though the law seems to permit that, you may run into some unintended consequences. For instance, the dignity and integrity of the office of the judge will be wiped out, for lack of a better word. So then, to avoid unintended consequence of disruption of service provision or dispensation of justice, if you like, then you defer this to the Judicial Service Commission. It is easier to prosecute a former judge than a serving judge. But again, also, in terms of our constitutional design, we have deference, some level of deference to international legal instruments. We have what is called the Latimer House principles on the relationship between the three arms of government. You have what you may consider the Bangalore principles on judicial conduct.
Okay. And it's getting a bit technical, but let me ask you this, because I need to let you go. Okay. Is it telling that this happened under Martha Kome's regime and not perhaps a David Maraga's?
I wouldn't want to pontificate in that manner, because then I will be entering into the arena of imagining what is in the mind of someone and then preferring an opinion based on my imagination. But I think there's been legitimate concern of executive overreach or revisit. This is happening just after the BBI judgment. Of course, it's bound to raise genuine concern whether these judges are being intimidated, because remember, Justice Agri Mchelule was one of the judges that were recommended for appointment. The Court of Appeal, he has not been appointed.
Yes.
Now we see him being arrested and proposed to be arraigned in court over corruption allegations. That may be seen in some quarters as trying to explain why he was not appointed to begin with. I think the party shot is this. The law permits, strictly speaking, the arrest and arraignment of judges in court. But for good order, and because of the judicial pronouncement on the issue, the court has already said definitively, and if there's doubt, we always defer to the court's pronouncements. The court has said, before you take that drastic step, because the reasons for arrest is because you feel there's an offense which has been committed, those proposed offenses can also actually lead to a removal. Why don't you present this evidence to the employer, let the judge be processed, let him be removed, then you can then prosecute.
Okay,
I think
Steve,
that is what is decent for everyone.
So clearly there's a lot that goes into this conversation, and so we will revisit. I want to thank you for taking the time to be with us. I hope you'll make it home before curfew. All right.
I'm an essential service provider.
All right, Steve, thank you.